Less than a week after the CDC updates immunization guidelines for the virus that shall remain nameless, a New York State trial judge rules a city worker immunization mandate invalid. Good morning, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. 2 days ago, October 24th, a New York State judge reinstated, with back pay, some 1,400 New York City workers who had lost their jobs for not complying with an immunization mandate. This decision strikes at the heart of such mandates everywhere in the United States. The judge decided, in essence, that no authority could punish someone for failing to protect himself. While this decision grants the basic premise of both the virus and of immunization against it, it holds that those who proposed the mandate failed to show that non-compliance made a person dangerous to anyone except himself or a similarly non-compliant person. The scientific premise of artificial active acquired immunity is that it protects the patient who accepts it. A mandate for immunization contradicts that premise, and a judge has shown that this contradiction is a mandate's greatest weakness. Before I dive into this, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. Be sure to check out the awesome CNAV Store. Scroll down near the bottom for that link. Lots of good merchandise there, especially this t-shirt that I have chosen for today, which quotes Aldous Huxley, of all people, saying, "Facts do not cease to exist because they are ignored." Well, as you will soon see, somebody ignored a basic premise of allergy and immunology when he said you could lose your job if you don't immunize. That makes zero scientific sense, and now a judge said it makes no legal sense either. One more thing. If you like what you're about to hear, you can like this video. You can also click the bell icon to get a notice every time I come out with a new one. In fact, do you see the new icon, the heart shape with a US dollar sign in it? That's the super thanks icon. If you really want to keep those videos coming, click that and leave me a tip. Any currency will do. Now, oyez, oyez, oyez! The New York State Supreme Court, in and for the County of Richmond, State of New York, the Honorable Judge Ralph J. Porcio presiding, decided the case of Garvey versus City of New York 2 days ago. Reportage on the decision comes from Just the News, the Daily Caller, and a site by commentator Todd Starnes. Yes, I said Supreme Court, but the phrase Supreme Court does not mean the same in New York as it does in other states. Just hang on, and I'll soon tell you all about the New York State Unified Court System and the weird way they have of referring to their courts. In the meantime, I've left a link in the description to Judge Porcio's decision. I've also left a link to a tweet by one Marina Medvin reproducing that decision. Judge Porcio ruled on two issues. First was a petition by George Garvey and 15 other persons for reinstatement to their New York City jobs. Second was a motion by the city to dismiss the petition. The city held that the petitioners had waited too long to file their petition. The judge said that, to the contrary, the city had never made a final determination in their cases. True, the city terminated these 16 employees and many others 8 months ago. But 4 months ago, the city said, in effect, comply with our mandate, you can have your jobs back. Therefore, they had not made a final determination of their status, and the petition was therefore timely. Next, the judge said the mandate was arbitrary and capricious. Here's the key. The city rescinded an immunization mandate for private sector employees of businesses operating inside the city, and never once did anyone show or even allege that an unimmunized person posed a risk to anyone but himself. nor did the city place any unimmunized person on leave. Thus, the judge held, the mandate was about compliance, not public safety or health. Now, I'm going to talk about the New York State Unified Court System, which is the unofficial name for New York State judiciary. They use many terms a lot differently from how most state judiciaries use them. What New York State calls its Supreme Court, other states call superior courts. These are trial courts. New York State calls its highest court, equivalent to the Supreme Courts of most other states, the Court of Appeals. The second highest court is the Appellate Division of the Supreme Court. So, now maybe I've solved the mystery of why actor William Frawley, who played Politico Charlie Halloran in the 1947 version of Miracle on 34th Street, than which there ain't been no witcher since, as far as I'm concerned, said this to his friend the judge in People versus Kris Kringle. Go on! Tell them that the New York State Supreme Court says that there's no Santa Claus. Go on! Mr. Garvey and his 15 co-petitioners filed their petition in Supreme Court. The city has already said they would appeal, and presumably that appeal will go to the Appellate Division. And given the tension between the two sides, it almost certainly will reach the Court of Appeals. And if you think that's a strange terminology, you ain't heard nothing yet. Massachusetts calls its legislature the General Court, and it calls other courts in the usual meaning judicial courts. Now, before I get into the nitty-gritty of Judge Porzio's decision, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You're not alone. Fluctuating economy, employment issues, unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, they can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy for your future. Now, here is what Judge Porzio said about that immunization mandate. He said that it violated separation of powers, denied to petitioners the equal protection of the laws under the New York State Constitution, and deprived them of their rights under substantive and procedural due process of law. Again, under the New York Constitution. He also said the health commissioner exceeded his lawful authority and acted in an arbitrary and capricious manner. Furthermore, all 16, and presumably that applies to the rest of those 1,400, are back on the payroll as of 6 o'clock a.m. October 25th and should receive back pay and salary from the day they lost their jobs. Now remember, Twitter user Marina Medvin posted the decision. She then added her own reaction, calling the mandate and the terminations a costly mistake on the city's part. I've left a link in the description to her second tweet and to 2 more tweets in the lengthy thread that follows. Now these are just my favorites. Now here's one user recalling when some, by no means all or even most, people cheered when they heard of another unimmunized person dying. And here's another user pointing out that certain persons unknown predicted that all those 16 people would be dead during the winter. Well, obviously that didn't happen. The rest of the conversation after the posting of the order contained questions of what this decision meant for private sector employees. Recall, that the city canceled its own private sector immunization mandate. This decision does not directly reinstate any private employee, but it sets a precedent. Calls to reinstate active duty military service members who have suffered discharges, most of them less than honorable, over similar mandates. A reminder that Pfizer stands accused of lying about whether their immunization preparation prevents transmission. Apparently no one can show that. Calls for an end to any immunization mandate for school children. Calls to stop, reverse, and prevent such mandates by voting for local, state, and federal candidates who stand against them. Now, the court did say that this was not a judgment on the effectiveness of immunization. It's a judgment on how the city treats its workers. But the way I read the order, the court accepted one premise that, ironically, any mandate contradicts. The premise is that immunization protects against infection, death from infection, or both. It might not protect perfectly, but it protects. So say the professors of allergy and immunology, and they've been saying it arguably since men like Edward Jenner, Louis Pasteur, Jonas Salk, and Albert Bruce Sabin had their practices. Now, we all recognize that not everybody agrees with that. Now, that's not the point. The point is that termination merely for not accepting immunization is not appropriate even if you grant the immunization premise. Consider, if any particular drug or device confers protection to the person using it, well, how does not using it endanger anybody except the non-user? Tellingly, the city never alleged that immunization prevented transmission. So the city could not allege that those workers posed a risk of transmission to anyone else, or at least any greater than the compliant ones did. Well, that leaves only the premise of herd immunity, the notion that once a certain proportion of the population is immune, the disease cannot reach the remaining non-immune because the agent will die first. Now, let me tell you something. Herd immunity has an awful name. We are not animals. But let's lay that aside. The premise of herd immunity still depends on a shaky chain of logic. But more than that, an immunization mandate would almost assume that herd immunity does not exist. In short, the mandate failed because it is logically inconsistent and indefensible. Furthermore, if the city wins at the New York State Court of Appeals, the petitioners might have a federal case on the basis of equal protection of the laws. I'd love to see Mr. Garvey and his friends take it to the United States Supreme Court. And let me remind you, New York State hasn't exactly done very well before the Supreme Court of the United States. Link in the description of the article, to the decision, to Marina Medvin's initial and second tweets, to 2 other tweets in reaction, and to conservative news and views. I've also left links to the awesome CNAV Store and oursilverlines.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link to this channel and links to the video that I did just 2 days ago concerning immunization, recommendations to add to the childhood immunization schedule. And at least to a video about New York State Rifle and Pistol Association versus Bruin, the other big case New York State lost. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.